Why does it get weird when the bus driver works for a charity instead of a burger chain? You still got hurt, but the paper trail can change shape like a superhero in a budget sequel. If a nonprofit causes an injury, you usually still make a claim the same basic way you would against any other organization. You tell their insurance company what happened, what it cost you, and why they should pay. The big difference is that some nonprofits have special legal protections that can limit how much money you can recover. That does not mean they are untouchable, but it can mean the scoreboard has fewer points than usual. Think of it like this. A for-profit company often plays with regular money rules, while a nonprofit may have extra shields because lawmakers wanted to protect groups doing public work. Hospitals, charities, schools, and churches can sometimes have these protections, but the exact rule depends on where the injury happened. That is why your lawyer usually starts by checking the state law first instead of making guesses like a movie detective with a bad hat. One state may treat a nonprofit almost like any other defendant, while another may cap damages or make the claim harder to prove. Sometimes the issue is not the nonprofit itself, but who was actually careless. If an employee, volunteer, or contractor messed up, the claim may go after the organization, the person, or both, depending on the facts. You also have to watch for special notice rules because some states make you send a formal warning before you sue certain nonprofits. Miss that step, and the court can slam the door like a strict principal on a Monday. Insurance matters a lot here too, because nonprofits often carry liability coverage just like for-profits do. The real drama is whether that coverage is enough, since a smaller policy can make settlement talks feel like trying to split one pizza among 10 hungry cousins. People sometimes assume a nonprofit cannot be sued because it is doing good, which is sweet, but not how injury law works. Good intentions do not fix broken stairs, sloppy security, or a falling shelf with a grudge. What changes most is the path, not the basic idea that negligence can still lead to compensation. You still need proof, like medical records, witness statements, photos, and the timeline of what happened, because facts are the most stubborn thing in the room. For-profits may have deeper pockets, but nonprofits can have stricter legal limits, and both can fight hard over fault. That means your claim may turn on details like whether the injury came from unsafe property, poor supervision, or a bad policy that should have been fixed already. If a nonprofit serves the public, people often expect it to be safe and well-run, which is fair. But in law, expectation is not enough. So we look at duty, breach, and harm, which is just a fancy way of asking who should have done what and who got hurt. Juries can also react differently when they hear the word nonprofit, because the word sounds noble, almost like it should come with a cape. Still, a courtroom is not a talent show, and sympathy cannot replace evidence. That is why preparation matters so much, since these cases can move faster or slower depending on the state and the organization's status. A careful lawyer will look for exemptions, insurance limits, deadlines, and any special filing rules before you say anything that could box you in. So yes, claims against nonprofits can be handled differently, but not in a mystical wizard way, just in a state law, notice rule, and insurance limit way. If you were hurt, the smart move is to get the facts together early and let the legal rules do the heavy lifting instead of guessing like it is trivia night. Do you want to learn more about our company? Check out our links in the description.